Okay, the U.S. Supreme Court came back with an important ruling affecting homeowner property rights. It came back sooner than expected, and even more interesting is the fact that the decision was unanimous, 9-0. And this will impact property rights in many states across the U.S., including Arizona. Now, in my last video, I promised that I would be watching the case regarding home equity theft that went before the U.S. Supreme Court. It was Tyler versus Hennepin County. And if you missed it, here's a quick recap of the case. Geraldine Tyler purchased a condominium in Hennepin County, Minnesota. And after an event that made her feel unsafe, she moved into an apartment in a senior community. Her unpaid condominium property taxes of $2,300 quickly climbed to $15,000 after penalties, interest, and fines. Then in 2015, the county confiscated and sold her condominium for $40,000. Obviously, quick math makes you wonder what happened to the $25,000 difference between the sales price and the unpaid taxes and fines. The county lawfully kept the entire amount. Even the 8th Circuit Court of Appeals ruled that this was lawful, dismissing Geraldine Tyler's case. So the task before the Supreme Court was to decide if keeping the surplus amount exceeding what was owed was a violation of the Fifth Amendment's Takings Clause, where government is prohibited from taking private property without just compensation. Now, this happened in Minnesota, but it's also legal in states such as Alabama, Arizona, Colorado, Oregon, Nebraska, South Dakota, Illinois, Massachusetts, Maine, New Jersey, and New York. Now, you may be asking how a law could exist where someone loses the entire equity in their property. What logic can Hennepin County use to say that they can keep the total proceeds, including the equity, above what is owed? Two things stuck out to me, and do remember, I'm not an attorney, so this is a layman's view and only my opinion. Feel free to chime in and comment in the space below and let me know what you think. I'd like to hear your opinion. First of all, property rights are mostly defined and enforced by state law. With 50 states, it's understandable that you could have different interpretations of property rights, benefits, and enforcement of liens. Not all states look at unpaid property taxes the same way. A key claim some states maintain is the owner lawfully forfeits all rights and interest in the property when they fall behind on property taxes, essentially wiping out their equity. Therefore, when they have no interest in the property, there is no takings, allowing the government to keep the total proceeds of any sale, and they cite cases that they believe support these laws. Another aspect to this approach is many of the governments and/or investors benefit financially. Another case, this one in Michigan, Raffaelli LLC versus Oakland County. And in 2014, the government foreclosed over an $8.41 property tax debt, which had grown to $285. The county sold the property for $24,500. And it was later ruled that this was unconstitutional under the Michigan State Constitution, but not a violation of the Takings Clause. And you can see how the interpretation of the Takings Clause is less than consistent state by state. Now let's look at the other side in support of Geraldine Tyler. The Pacific Legal Foundation that represented Geraldine Tyler argued that a long-standing principle is that the government may not take from a taxpayer more than is owed. This concept is rooted in English law, and its origin goes back as far as the Magna Carta. In addition, 8 states, Arkansas, Kansas, Kentucky, Louisiana, North Dakota, Texas, Utah, and West Virginia, filed an amicus brief in support of Tyler. Now, interestingly, during the oral arguments, 2 justices had questions that I believe put the whole thing into perspective. Justice Kagan asked, if you had a $10,000 income tax bill due, and the government came in and took your $100,000 bank account and didn't give you the $90,000 back, is that a taking? Good job, Justice Kagan. A little later, Justice Barrett asked, what about the hypothetical if you owe like $20 of parking tickets? Can the state just take your whole car? Very well said. Fortunately, after considering both sides, on May 25, 2023, the Supreme Court ruled unanimously in favor of Geraldine Tyler that Hennepin County violated the takings clause. Chief Justice Roberts wrote in the unanimous decision, the taxpayer must render unto Caesar what is Caesar's, but no more. This decision will set a precedent at the highest level and have a significant impact on many states that one way or another use a system that takes the homeowner's entire equity when there are delinquent property taxes. Arizona is a tax lien state where after a 3-year redemption period, owners can lose their property and all the equity through a judicial foreclosure. The next step is how this ruling affects states such as Arizona. Will the approach now be similar to what happens with a foreclosure or when a homeowner doesn't pay their mortgage and there's a public auction? Interestingly, in 2020, Arizona House Bill 2445 was introduced. It would have provided a way for the previous homeowner to claim the surplus equity, but it never became law. Let's see how Arizona and other states handle this new Supreme Court ruling. I look forward to your feedback in the comments below. Thank you.